Okay, we're back and we're going to try this again. See if we can wait for a few people to show up. Of course, we're going to talk about that birth certificate again tonight. But basically, we're going to pass over that. We're just going to mention it and pass over that to a couple other details in regards to the process of taking care of business, basically. And what we're talking about here is in regards to the state trustee and everything, over the birth certificate, what they're doing is they're taking on a position of a trustee, and they're going to benefit from that. They're going to get financial gain for taking on a fiduciary duty, and therefore they're going to get compensated. They're going to get a benefit. So either way, they're going to benefit. In doing so, as trustee of that estate, they're going to offer you benefits. Now, you may not look at them as benefits, but they're benefits according to their presumption that you haven't stepped up and taken position of the proper capacity to take care of your own business. And that's why you're in their court, and somebody else is handling the banking. We always hear that the bench stands for bank, and then the judge is acting as the banker, and that's exactly what they're doing. The proper way to think about this, and we all hear that we're the bank, correct. And so when I talk about the birth certificate authenticated through the state, Secretary of State, in regards to providing a passport for non-Hague countries such as Taiwan, and then you're going to send it off to the U.S. Department of State, and they're going to authenticate the state's authentication. And then you can present it for a passport. Now, the next step most people take is, of course, authenticating the birth certificate, or doing the DBA and UCC1. And so that's what we're going to do next. But when you think about this stuff, in regards to the banking, if they're truly being the bank or acting as bankers, and you want to resolve that, then you have to be the bank. Well, how do we be a bank? Well, if you look at your doing business as thing in Minnesota under rule number 22, and remember, they have a specific type of joinder in regards to rights when it comes to being able to file in one state. That filing is effective in all states. And that's why everybody goes to Minnesota and does the Minnesota Rule Number 2, because it applies in all states and it's most effective. Well, here in Iowa, as well as any other state, they have the same thing set up according to their rules. But again, you refer to that, basically it's equal rights and privileges in regards to the state. And when you're doing the Minnesota Rule Number 22 and it applies to every other state, no matter what that other state is putting forth as a DBA, as such as in Iowa, they put out what's called a fictitious name resolution. It still, even though it's got its own wording, it still has to be in accordance with the Minnesota rule. Just like the Minnesota rule has to be in accordance with the United States Code. Just like the United States Code has to be in conformity with the UCC. And that's your banking code. And so when we look at the different forms in the different states, and we start looking at the wording on them, we begin to educate ourselves on what the DBA is all about. And so I'm going to read this one here. I'm going to see if I can switch my camera around here so we can just... Well, that wasn't it. Huh. Let me see if I can figure out how to turn this camera around. Well, I can't figure it out from there, but we're going to see if we can show you from here. If we look at the top, you got the Secretary of State and everything, and it's going to be backwards here, but it says Paul D. Tate, Secretary of State, State of Iowa. And then we look over here and it says fictitious name resolution. And under that, I've got a little note that says Minnesota Rule 22. And the thing about the states complying with each other is based upon your intent, the effect, and the enforcement. And so if the Minnesota rule number 22 has shows a specific intent and the effect of that intent, and it's applicable through enforcement, then that's where we see how it applies to the other states in accordance to the banking laws. Because that's what they're doing. They're following the banking laws and providing this DBA rule number 22. So the other states have to follow it no matter what they call it. So then we look on this form and it says I, and then it's got a blank for you to put your name in there. It says certify that I am the, and then it's got several different sections, and it goes on to say secretary, chapter 490 and 504, general partner, chapter 488, authorized person, chapter 489 and 524, presiding officer of the board of directors or other association officer, chapter 499, or officer, chapter 501A. Now these are all accordance to the Iowa State statutes. But again, like I said, they follow the UCC because the USC does, and they're bound by the USC. The USC is bound by the UCC. So it's still UCC. And what it says here is the business entity subject to the provisions of, and then it's got different setups as to how you can set your business up. You can set it up as a Iowa Business Corporation. You can set it up as a non-profit corporation. You can set it up as a uniform limited liability. You can set it up as a uniform limited partnership. You can set it up as a cooperative. You can also set it up under the Iowa Banking Act. Requires approval of Iowa Division of Banking. Now, if we look at the United States Code in regards to their banking, it says 28 USC 581, and in that and that's the definition of a bank. And in that definition of a bank, it goes to tell you, and remember where you see this word, and go ahead and look this up, 26 USC 581. And in that definition, it will tell you, and it uses the word or after it gets into it, and you'll see this, it says, or exercising fiduciary powers similar to those permitted to national banks under authority of the Comptroller of Currency. Okay? So as long as you're conforming to the Uniform Commercial Code in regards to being a bank, that makes you, as the CEO, the banker. Now, when you go into court with this durable power of attorney over your estate as the banker, they have no other thing to do except listen to you. That's the safest way to protect yourself, is by being the banker. Because that's what they're doing, is they're acting as trustee and therefore sitting in the position of a banker in your banking transactions because you haven't stepped up to the plate and done that. When you do that, whether it be through a LLC, and then, of course, always remember, this has to be done under durable power of attorney in fact. If you decide to do a DBA as a regular LLC or something, that's fine too. But then you've got that durable power of attorney in fact, so that you can send a banker in to do your banking transactions in these bank courts. Because that's what they're doing. They're constructing banking transactions through contracts and trusts. And the more you understand that, the more you'll realize how much power you really have. Until then, use that durable power of attorney in fact to mitigate or administrate your affairs by assigning the powers to somebody else that has more knowledge of how it works and everything. And again, make sure you're assigning people that you trust, people that you know will conduct your affairs in your good faith, unlike the government. Because again, like I said before, as trustees, they're going to benefit through compensation. And they're going to benefit as much as possible by drawing it out as long as possible. And that's a play on your ignorance. The longer you stand there and question this and question that and question this, oops, sorry there. The longer you question this and question that, the longer they're going to play on that ignorance and draw that court case out and make more money, because they're acting more. They're performing more acts of trustee as bankers. So understand this stuff. The prosecutors, same with the public pretenders that they assign you. Don't take on those attorneys. Take on durable power of attorney in fact for your own self, your estate, and your estate. There's three. That's the trilogy of your estate. You've got the all caps estate named in all capital letters, and that's capital E, capital S, capital T, capital A, capital T, capital E. That's your estate. Then you have your estate, which is capital E, S, or lowercase s, lowercase t, lowercase a, lowercase t, lowercase e. Your estate, all caps estate, is the trust that protects all of your property. You put all of your property into it. That's your estate. Your estate is your property. You're going to put that into it. Your estate is yourself. Lowercase e, lowercase s, lowercase t, lowercase a, lowercase t, lowercase e. Yourself, your property, and your trust. Those are your three estates. Learn this stuff and understand how to be the banker for all of those positions, and understand your DBA with your Minnesota Rule number 22, like I said. And I said this before too. You don't have to use their forms. When you want to use their forms, or they try to make you use their forms, go ahead and use them if you want. But like I'm doing on this one, I'm going ahead and making amendments on them and having it ready so that they want to make me use this one rather than my own draft, one that I'm going to draw up myself, and filing into the public record. Then it's an adhesion contract. They can either accept it or leave it. They're not going to leave it because they want me to be the banker. They have to accept me as the banker because that's my position and nobody else can claim it. If I'm going to step up into the position of a banker for my estate and I've got the durable power of attorney in fact, they have to do what I tell them. So whether it be their form or a document of my own, as long as it's doing the exact same thing, then they have to do what it's telling them. So as long as I incorporate all of this information, or all the correct and proper information, such as through the DBA in Minnesota, I can take information from the Arizona one, the Texas one, the Alaska one, Hawaii one, Rhode Island. I can take information from all those different forms, combine them all into my own format. It's up to you, and that's how you delegate your own responsibilities, your own affairs, whether they be business or private. And that's what you have to realize. That's your power. You make your own choices based upon your own beliefs, and you have the right to change your mind depending on when those beliefs change and how they change. And they do all the time. Anyway, don't want to make this too long, but understand that, again, that the age of majority, durable power of attorney in fact, nationality, authenticate that birth certificate both through the Secretary of State and U.S. Department of State, do your DBA in Minnesota, and then do your UCC1. Now wait till these people see my the names that I declare on my UCC1. Yeah, let's see here. Keith Little Estate Bank and Trust. Or how about that one on my new page, Fuking Big Dick. Yeah, they'll like that one. I'm going to start up a company called Fuking Big Dick. See how they like that. And they'll have to process my paperwork because that's my enforcement. There's nothing they can do about it. That's my decision. That's my choice. And so they have to use it. Anyway, think about that stuff, people. Get it in gear and get this stuff done. Because until you do, they're going to keep being the banker. And they're going to slam down that gavel and sentence you to charges. Anyway,